Welcome to the appendix, where we read the primary sources of the past so that the present can be better understood. Today's primary source, the Judiciary Act of 1789, September 24th, 1789, as found in U.S. Statutes at Large, Volume 1, page 73. The Constitution provided only for a Supreme Court, and such inferior courts as the Congress may from time to time establish, thus leaving the whole question of the nature of the organization of the judiciary to the discretion of Congress. The framework of the American judicial system was created in the Act of 1789. The determination of the first Congress to create a federal judiciary was of immense importance in developing American nationalism. An act to establish the judicial courts of the United States. Section 1. Being enacted that the Supreme Court of the United States shall consist of a Chief Justice and 5 Associate Justices, any 4 of whom shall be a quorum, and shall hold annually at the seat of government 2 sessions, the one commencing the first Monday of February, and the other the first Monday of August. That the Associate Justices shall have precedence according to the date of their commission, or when the commissions of 2 or more of them bear date on the same day, according to their respective ages. Section 2. That the United States shall be, and thereby are, divided into 13 districts, to be limited and called as follows. Section 3. That there be a court called a district court in each of the aforementioned districts, to consist of 1 judge, who shall reside in the district for which he is appointed, and shall be called a district judge, and shall hold annually 4 sessions. Section 4. That the aforementioned districts, except those of Maine and Kentucky, shall be divided into 3 circuits, and be called the Eastern, the Middle, and the Southern Circuit. That the Eastern Circuit shall consist of the districts of New Hampshire, Massachusetts, Connecticut, and New York. That the Middle Circuit shall consist of the District of New Jersey, Pennsylvania, Delaware, Maryland, and Virginia. And that the Southern Circuit shall consist of the districts of South Carolina and Georgia. And that there shall be annually in each district of said circuits 2 courts, which shall be called circuit courts, and shall consist of any 2 justices of the Supreme Court, and the district judge, and such districts, any 2 of whom shall constitute a quorum, provided that no district judge shall give a vote in any case of appeal or error from his own decision, but may assign the reasons of such his decision. Section 9. That the district courts shall have, exclusively of the courts of the several states, cognizance of all crimes and offenses that shall be cognizable under the authority of the United States, committed within their respective districts, or upon the high seas, where no other punishment than whipping, nor exceeding 30 stripes, a fine not exceeding $100, or a term of imprisonment not exceeding 6 months, is to be inflicted, and shall also have exclusive original cognizance of all civil cases of admiralty and maritime jurisdiction, including all seizures under laws of impost, navigation, or trade of the United States, and shall also have cognizance concurrent with the courts of the several states, or the circuit courts, as the case may be, of all causes wherein an alien sues for a tort only in violation of the law of nations or a treaty of the United States, and shall also have cognizance concurrent at last mentioned of all suits at common law where the United States sue, and the matter in dispute amounts, exclusive of costs, to the sum or value of $100, and shall also have jurisdiction exclusively of the courts of the several states, and all suits against consuls or vice-consuls, except for offenses above the description aforesaid, and the trial of issues, in fact, in the district courts, in all cases except civil causes of admiralty and maritime jurisdiction, shall be by jury. Section 11. That the circuit court shall have original cognizance, concurrent with the courts of the several states, of all suits of a civil nature, at common law or in equity, where the matter in dispute exceeds, excessive of the cost, the sum or value of $500, and the United States are plaintiffs or petitioners, or an alien is a party, or the suit is between a citizen of the state where the suit is brought and a citizen of another state, and shall have exclusive cognizance of all crimes and offenses cognizable under the authority of the United States, except where the act otherwise provides, or the laws of the United States shall otherwise direct and concurrent jurisdiction with the district courts of the crimes and offenses cognizable therein. And the circuit courts shall also have appellate jurisdiction from the district courts under the regulations and restrictions hereinafter provided. Section 13. That the Supreme Court shall have exclusive jurisdictions of all controversies of a civil nature, where a state is a party, except between a state and its citizens, and except also between a state and citizens of other states or aliens, in which later case it shall have original but not exclusive jurisdiction, and shall have exclusively all such jurisdictions of suits or proceedings against ambassadors or other public ministers, or their domestics or domestic servants, as a court of law can have or exercise consistently with the law of nations, and original but not exclusive jurisdiction of all suits brought by ambassador or other public ministers, or in which a consul or vice-consul shall be a party, and the trial of issues, in fact, in the Supreme Court in all actions at law against citizens of the United States shall be by jury. The Supreme Court shall also have appellate jurisdiction from the circuit courts and courts of the several states in the cases hereinafter specially provided for, and shall have power to issue writs of prohibition to the district courts when proceeding as courts of admiralty and maritime jurisdiction, and writs of mandamus in cases warranted by the principle and usage of law to any courts appointed or persons holding office under the authority of the United States. Section 25. That a final judgment or decree in any suit in the highest court of law or equity of a state in which a decision in the suit could be had, where is drawn in question the validity or a treaty or statute of or an authorized exercise under the United States, and the decision is against their validity, or where is drawn in question the validity of a statute of or an authority exercised under any state, on the grounds of their being repugnant to the Constitution, treaties, or laws of the United States, and the decision in the favor of such their validity, or where is drawn in question the construction of any clause of the Constitution, or of a treaty, or statute of, or commission held under the United States, and the decision is against the title, right, privilege, or exemption specially set up or claimed by either party under such clause of the said Constitution, treaty, statute, or commission, may be re-examined and reversed or affirmed in the Supreme Court of the United States upon a writ of error, the citation being signed by the Chief Justice or Judge or Chancellor of the court rendering or passing the judgment or decree complained of, or by a Justice of the Supreme Court of the United States in the same manner and under the same regulations, and the writ shall have the same effect as if the judgment or decree complained of had been rendered or passed in a circuit court, and the proceedings upon the reversal shall also be the same except that the Supreme Court, instead of remanding the case for a final decision, as before provided, may, at their discretion, if the cause shall have been 1. Remanded before, proceed to a final decision of the same, and award execution. But no other error shall be assigned or regarded as a ground of reversal in any such case as aforesaid, than such as appears on the face of the record, and immediately respects the before mentioned questions of validity or construction of the said Constitution, treaties, statutes, commissions, or authorities in dispute. Section 35. And there shall also be appointed a meet person learned in the law to act as Attorney General for the United States, who shall be sworn or affirmed to a faithful execution of his office, whose duty it shall be to prosecute and conduct all suits in the Supreme Court in which the United States shall be concerned, and to give his advice and opinion upon questions of law when required by the President of the United States, or when requested by the heads of any of the departments, touching any matters that may concern their departments, and shall receive such compensation for his services as shall by law be provided. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.